Hello viewers, Namaskar. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. Today, we will be dealing with the various kinds of punishments that have been provided under the new laws. In the previous session, we discussed under what circumstances and what are the crimes in which cases death can be awarded. Death penalty, that is to be executed in India by hanging till death. So, the cases in which death penalty may be awarded was discussed in the previous lecture. Now, we will continue further and first of all we will discuss what is the difference between death and life imprisonment. See, prior to the Criminal Procedure Amendment Act of 1955, in our country, death penalty was the rule and life imprisonment was an exception in capital offences also as per the provisions of the old CRPC. Here I am talking about the CRPC of 1898. So, courts, they were bound to give an explanation for awarding a lighter penalty than death for capital offences. See, that is because that was an old law which was enacted by the Britishers. The objective of substantive criminal law was to punish, and we had a procedural law which was merely laying down the procedure for executing the punishments that had been laid down in the Indian Penal Code. And that is why at that time the maximum punishment which was prescribed by the courts was something which the courts were mandated to give, and in case the courts decided that no, we have not to award the maximum prescribed punishment, then it was a burden on the courts to give explanation and justification as to why did they award a lesser penalty than what was prescribed for that crime. After our independence, when we enacted our constitution, thereafter we had amendments in our criminal laws. So, after the amendment of 1955 now, our courts were at liberty to grant either death or life imprisonment. Then, as per section 354, subsection 3 of the Criminal Procedure Code 1973, the situation was reversed and life sentence became the rule and death penalty an exception in capital offences. See, why was this change brought about? Because after independence, when we amended our procedural law to constitutionalize the same, because by that time we had our constitutional principles. So now what was done, that even in those offences where death penalty and life imprisonment have been prescribed as a punishment, now the courts as it is, they were supposed to give life imprisonment, and in case they wanted to award death penalty, so that was an exception, and the courts were now required to state reasons as to why were they awarding the maximum penalty when there was an option of available for sentencing the accused to life imprisonment. So now this is a trend which remains unchanged. Even after we have now replaced the old IPC and CRPC with Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita respectively. See, in the case of Rajendra Prasad versus State of UP, this is a 1979 judgment of the Supreme Court of India, while addressing the issue of judicial discretion in the award of death penalty, the court held that since law reflects life, new meanings must permeate the penal code. Deprivation of life under our system is too fundamental to be permitted except on the gravest ground and under the strictest scrutiny. At the same time, the social justice which preamble and part 4 of the Constitution, more specifically Article 38 highlight, as paramount in the governance of the country, has a role to mold the sentence. If the murderous operation of a die-hard criminal jeopardizes social security in a persistent, planned and perilous fashion, then his enjoyment of fundamental rights may be rightly annihilated. Thus, there is a need to read section 302 of the IPC. We are talking regarding punishment of murder that was prescribed under 302 of the IPC, and section 354 subsection 3 in the humane light of part 3 and part 4 further illuminated by the preamble of our constitution. So, further in the same case, while laying down guidelines for the judicious exercise of discretion by the courts, it was emphasized that the special reasons stated by the court in awarding death penalty must relate to the criminal as well and not to the crime alone. So, you see, there have to be aggravating factors, there have to be mitigating factors, and while awarding death penalty, the courts, they have to see look at the criminal, whether he is a first time offender, whether he is a repeat offender, okay, and what was his background, what were the conditions under which the person committed the crime, and then what was the manner in which the crime was executed, what is the gravity of the crime, and how did the accused act at the time of the commission of the crime, prior to the commission of the crime, subsequent to the commission of the crime, whether it was pre-planned, barbaric, cold-blooded. So, all these things, they have to be kept in mind before the courts, they decide whether death penalty has to be awarded. So, we have to apply the crime test as well as the criminal test. All this needs to be considered, and only then the courts, they have to arrive at a judicious decision whether this is a case which merits the award of the extreme penalty of death which has been prescribed under the law. See, there is a landmark judgment, Bachchan Singh versus State of Punjab. This is a 1980 judgment of the Supreme Court of India, in which the court held that the constitutional validity of death penalty for murder provided in section 302 Penal Code and the sentencing procedure embodied in subsection 3 of section 354 of the CRPC, and this was referred for consideration to a constitution bench of the Supreme Court, and the court upheld the constitutionality of the aforesaid provisions and propounded the dictum of rarest of rare cases, according to which death penalty is to be not awarded except in the rarest of rare cases where the alternative option is unquestionably foreclosed. So, what we have to see is whether a case falls in the category of rarest of rare cases, only then can we unquestionably foreclose the other option of life imprisonment. Okay. So, death penalty, it may be awarded, but there is a test that has been propounded by our judiciary, and that is the rarest of rare cases. Then, how about award of mercy petition in death sentence cases? We always hear about that. So, section 472 of BNSS is a new provision now, in which what the law says, a convict under the sentence of death or his legal heir or any other relative may, if he has not already submitted a petition for mercy, file a mercy petition before the President of India under Article 72 or the Governor of State under Article 161 of the Constitution within a period of 30 days from the date on which the Superintendent of the jail informs him about the dismissal of the appeal, review or special leave of appeal by the Supreme Court, or informs him about the date of confirmation of sentence of death by the High Court and the time allowed to file an appeal or special leave in the Supreme Court has expired. Subsection 2. The petition under subsection 1 of section 472 may initially be made to the Governor, and on its rejection or disposal by the Governor, the petition shall be made to the President within a period of 60 days from the date of rejection or disposal of such petition. Subsection 3. The Superintendent of the jail or officer in charge of the jail shall ensure that every convict, in case there are more than one convict in a case, also files the mercy petition within a period of 60 days, and on non-receipt of such petition from the other convicts, Superintendent of the jail shall send the names, addresses, copy of the record of the case and all other details of the case to the central government or the state government for consideration along with the said mercy petition. Subsection 4. The central government shall, on receipt of the mercy petition, seek the comments of the state government and consider the petition along with the records of the case and make recommendations to the President in this behalf as expeditiously as possible within a period of 60 days from the date of receipt of comments of the state government and records from the superintendent of the jail. Then under subsection 5, the President may consider, decide and dispose of the mercy petition, and in case there are more than one convict in a case, the petition shall be decided by the President together in the interest of justice. And upon receipt of order of the President on the mercy petition, the central government shall within 48 hours communicate the same to the Home Department of the state government and the superintendent of the jail or officer in charge of the jail. No appeal shall lie in any court against the order of President or the Governor made under Article 72 or Article 161 of the Constitution, and it shall be final. And any question as to the arriving of decision by the President or the Governor shall not be inquired into by any court. Next, we come to the issue of solitary confinement. See, man is a social animal. So, when a person is to be awarded a solitary confinement as a punishment, there have to be special reasons. Under section 11 of the Bharatiya Nyaya Sanhita, whenever any person is convicted of an offence for which under the court has power to sentence him to rigorous imprisonment, the court may by its sentence order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in the whole, according to the following scale, that is to say, a time not exceeding 1 month, if the term of imprisonment shall not exceed 6 months, a time not exceeding 2 months, if the term of imprisonment shall exceed 6 months and shall not exceed 1 year, and a time not exceeding 3 months, if the term of imprisonment shall exceed 1 year. So, section 11 empowers the courts to impose solitary confinement on certain categories of hardened criminals in cases of severe crimes. See, what is done? Such people, they are confined in a separate cell where all their connections to the outer world are severed. In Munnu Swami, this is a 1948 old judgment by the Madras High Court, it was held that solitary confinement is an extreme measure and it is to be rarely invoked in exceptional cases of unparalleled brutality and atrocity. See, man by nature is a social animal, and there can be no greater punishment than keeping a human being in isolation from his other fellow human beings. So, limits have been imposed on solitary confinement under section 12 of the Bharatiya Nyaya Sanhita. So, in executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a stretch. And law makes provision for intervals between the periods of solitary confinement of not less than the period of such confinement. And in cases where term of imprisonment awarded exceeds 3 months, the solitary confinement shall not exceed 7 days in any 1 month of the whole term of imprisonment awarded, and that too with intervals between the periods of solitary confinement of not less duration than those periods. So, after talking about death penalty and solitary confinement, let us talk about imprisonment for life, which shall mean the remainder of that person's natural life. So, it can be awarded in the following cases. 64 subsection 2, in this section which prescribes punishment for rape by a person in authority. Next is section 65 subsection 1, rape on a woman under 16 years of age. 65 subsection 2, rape on a woman under 12 years of age. Section 66, inflicting injury leading to death or persistent vegetative state due to offence of rape. Section 70, gang rape. Section 71, repeat sex offenders. Section 104, murder by life convict. Section 109, subsection 2, attempt to murder by life convict if hurt is caused. Section 139, subsection 2, maiming a child for purpose of begging. Section 143, subsection 6, person convicted of trafficking a child on more than one occasion. Section 143, subsection 7, public servant involved in trafficking of person. So, that is imprisonment for life which shall mean remainder for a person's natural life. Now coming to imprisonment for life. So, contrary to popular perception, imprisonment for life amounts to imprisonment for the whole of the remaining period of the convict's natural life. It does not mean only 14 years. So, convicts undergoing life imprisonment, they are housed in the central prisons of the concerned states. And life imprisonment is always rigorous, never simple. Life imprisonment was introduced in the Indian Penal Code in 1955 as a substitute for transportation for life. See, transportation for life was a colonial punishment which implied banishment for the convicts from Indian territories to Central Jail in Andamans or other British colonies where they were made to do hard labour for their life. Under section 5 of the Bharatiya Nyaya Sanhita, the appropriate government has the power to commute any punishment under this Sanhita without the consent of the person sentenced to any other punishment in accordance with section 474 of the Bharatiya Nagarik Suraksha Sanhita. So, if the state wants, it can reduce the punishment from a difficult form to a maybe milder form, and that can be done even without taking the consent of the person who has been sentenced. See, death sentence to life imprisonment, that is, such person cannot be released before 14 years. So, this is the formula that the state follows. If a person has been sentenced to death, so his punishment can be changed to life imprisonment. If a person has been sentenced to life imprisonment, then it can be imprisonment for a term which shall not be less than 7 years. Someone who has been awarded imprisonment for 7 years or more, so that person's sentence can be reduced to imprisonment for a term which shall not be less than 3 years. Then somebody who had been sentenced to imprisonment of less than 7 years, then such a person can be sentenced to mere fine, and rigorous imprisonment can be commuted to simple imprisonment for the same term. So, the state can on its own take decision in this regard. See, although convicts cannot as a matter of right claim automatic release after 14 years, in practice, however, life imprisonment means incarceration for 14 years, after which lifers become entitled to remission of the rest of the sentence. Now, this is as per prison manual provisions. So, section 6 of the Bharatiya Nyaya Sanhita lays down that in calculating terms of fractions of punishment, imprisonment for life is to be reckoned as equivalent to imprisonment for 20 years. Now, why do we need this kind of calculation? See, this is particularly useful when we have to determine the term of imprisonment under sections 56, 59, 60, 62, which deal with abatement, which deal with attempt. Now, what the law lays down is a formula. That is, if a person attempts to commit a crime, the person can be punished with half of the maximum sentence that is prescribed for that offence. So, that is where this calculation comes into play. Suppose the maximum sentence that was prescribed for that offence was life imprisonment, then in such case it would be reckoned as equivalent to imprisonment for 20 years. Now, there is another issue. Many times the accused persons, they demand some sort of wages for hard work that they do during rigorous imprisonment. See, Chapter 7 of the Prisons Act 1894 deals with employment of the prisoners. There is no provision in the Act for payment of wages to criminal prisoners who are sentenced to hard labour. But in the case of People's Union for Democratic Rights and others versus Union of India and others, this is a 1982 judgment by the Supreme Court. In this case, the Supreme Court had ruled that it was the mandate of our constitution that prisoners are to be paid wages for the work done by them. Even otherwise, you see, our constitution, it forbids begar. But in the case of State of Gujarat versus Honorable High Court of Gujarat, 1998, the Supreme Court further clarified that, see, while undergoing rigorous imprisonment, a prisoner is forced to do hard labor as part of his punishment for the crime that is committed by him, and the punishment has been imposed upon him by a court of competent jurisdiction in accordance with the law. So, you see, such labor cannot be equated with begar or other similar forms of forced labor, and there is no violation of clause 1 of Article 23 of the Constitution. See, clause 2 of Article 23 also has an application in such a case. Constitution, however, does not bar a state by appropriate legislation from granting wages to prisoners subject to hard labor under court's orders for their beneficial purpose or otherwise. So, as it is, states, they are at liberty to enact their own rules, and they can provide minimum wages to prisoners who are made to do hard labor, but that is not a right of the accused person. That is the benevolence of the state. They have been asked to do hard labor because they have committed a crime for which they were sentenced to hard labor in accordance with the law of the state. Then the other kind of punishment that has been prescribed in the law is fine. So, fine as a punishment may be imposed with or without imprisonment. There are some petty offences for which the only punishment prescribed is fine. Punishment of fine brings home the sense of responsibility in a surer fashion than even short terms of imprisonment in some cases. So, according to section 8(1), if the amount of fine is not mentioned in the statute, then the fine may be unlimited but not excessive. The relevant considerations for fixation of the amount would be the nature of the offence and the capacity of the offender to pay. Section 8, subsection 2 provides for imprisonment in default of payment of fine. This section is applicable where the offence is punishable with imprisonment with fine, with imprisonment or fine, or with fine only. Thus, it is clear that this section is not to be applied in cases where offence is punishable with death. According to section 8, subsection 3, there is a limit to which the offender may be imprisoned in default of fine, and such term shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for that offence. Section 8, subsection 4 provides that the imprisonment which the court imposes in default of payment of fine may be of any description to which the offender might have been sentenced for the offence, and whenever the fine is paid, the imprisonment in lieu of its default shall terminate forthwith. Now, is imprisonment a substitute for fine? See, imprisonment in default of fine does not absolve the accused from his liability to pay fine. Imprisonment in default of fine is a punishment for non-compliance with the orders of the court, and the fine stands unpaid, which is recoverable from the offender within 6 years after the passing of the sentence or at any time during the imprisonment. And then Section 8, subsection 7 expressly provides that, see, even death of the offender shall not discharge his liability to pay fine, and the fine would be recovered from the property of the offender even after his death. Now, viewers, let us talk about community service, which is a new kind of punishment, a progressive punishment introduced in the BNS. So, community service may be understood as work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. So, this is a form of non-custodial restorative justice, and it is an attempt at re-socializing the convict. So, this has been introduced by BNS in 6 cases, in 6 offences which are of a petty nature. See, it has been introduced in cases of non-appearance in response to a proclamation under section 84 of the BNSS, in cases of involvement of public servant in illegal trade under section 202 of the BNS, in cases of attempt to commit suicide to compel or restrain exercise of lawful power of public servant under section 226 of the BNS, in cases of theft. Then this is given under proviso to section 303, that is, community service in theft is to be awarded only where the offender is a first time offender, the person has committed a theft of a property which is less than 5,000 rupees of value, and the accused is willing to give back the property or compensate for the loss that was caused. Then in such cases the offender can be let off with a community service. Then it is also to be awarded in misconduct in public by a drunken person under section 355 of BNS, and in cases of defamation under section 356 of the BNS. See, abetting commission of offences by public or by more than 10 persons. So now this was a crime for which under section 117 of the IPC there was imprisonment up to 3 years or fine or both. Now the penology has revised, and under section 57 there is punishment of either description for a term which may extend to 7 years or with fine. Similarly, in cases of offences of buying child for purpose of prostitution, under section 99 of the BNS, the word child has been substituted for person, and imprisonment prescribed is now not less than 7 years, but which may extend to 14 years. Earlier it prescribed imprisonment only up to 10 years. Similarly, in cases of cheating, punishment has been increased from 1 year to 3 years under section 318 of the BNS, and punishment by way of imprisonment for cheating a person whose interest the offender was bound to protect, there the punishment has been increased from 3 years to 5 years, and in cases of cheating for personation there is an increase from 3 years to 5 years. And when offence of cheating is punishable under 318 and when it is punishable under 112, there is a difference. That is, see, if cheating is committed by an offender as a member of a gang or a group, then offence of cheating is punishable under 112 as petty organized crime, but if it is committed by the person individually, not as a part of gang, then it is punishable under 318. Similarly, making atmosphere noxious to health, the amount that was of fine that was prescribed, it has been doubled from 500 to 1000. Then intentional insult with intent to provoke breach of peace, mandatory summary trial has been prescribed. Then in this case it is to be mandatorily tried, and earlier it was summarily triable by magistrate at his discretion. But now it is to be mandatorily tried summarily by magistrates. Causing death by negligence, also there is an increased punishment. And so the new law also increases the punishment for causing death by negligence from a maximum of 2 years to a maximum of 5 years now. In cases of FRA also, the amount of fine has increased tenfold from 100 to 1000. In negligent conduct with respect to animal, fine has increased fivefold from 1000 to 5000. Then a deserter who is concealed on board a merchant vessel through negligence of master, fine has increased from 500 to 3000. Similarly, in abatement of mutiny, abatement of act of insubordination by soldier, sailor, airman wearing garb or carrying token used by soldier, sailor, airman, or assault or criminal force in attempt to wrongfully confine a person, here also the prescribed fine has increased fivefold from 1000 to 5000. So you see, these are some cases wherein the fine has been increased. So this was a session in which we discussed the various kinds of punishments that are prescribed under the law and what are the changes that have been brought about in the scheme of punishments in our new criminal laws. So viewers, that will be all for the day. Thank you. Jai Hind.